On to the big corporate story of the day. It's a massive victory that came in for the Tata Group and Ratan Tata, who said it's time to now stop whining. That was part of his statement. We're, of course, talking about one of the biggest boardroom battles we've seen in our lifetime. Ratan Tata versus Cyrus Mistry, and the massive victory for the Tata Group from the Supreme Court. Harish Salve, senior counsel, who appeared for Tata Sons, joined ET Now live all the way from London. Here he is.
Bitter or otherwise, I don't know. But yes, it's been a long battle and I'm happy it's ended. It's never good to have a cloud like this hanging on one of largest corporate houses. And all sorts of gossip about what has been found, what has not been found. So I think, as Mr. Ratan Tata said, more than anything else, it's a clear vindication for what they did. And I think we are all very satisfied with the way it has gone.
Mr. Salve, now going forward, the fact is that Cyrus Mistry will stay as a minority shareholder. The Supreme Court has found no case of mismanagement or of oppression of a minority shareholder. However, it has left the window open as far as any exit goes, any valuation of shares goes. My question to you is that is the Tata Group at all even interested in providing an exit to the Cyrus Mistry camp as it has sought?
There was a time when they had offered, and this is a decision they will have to take. Frankly, I have not even seen the judgment. What I heard from what was pronounced in court is that the misadventure of suggesting that the Tata Group be carved up with 18% value assets being handed over to Mistry had been rejected. And the court has pointed towards Article 75. Now, Article 75 comes tagging on with an exit formula and an exit price. So all that will have to be worked out. And I don't think anybody has done the math to decide whether they have or have not decided to ask him to quit. From his point of view, I am also not sure whether he would want to leave. I believe when he had applied for permission to pledge the shares, they said there is a cash bind, and Supreme Court has held that these shares cannot be transferred and a pledge is a transfer. So I don't think he can monetize these shares as such. So I think it might be in everybody's interest if the Tatas are so inclined to sit across the table and resolve it.
Is the Tata camp interested in sitting across the table and resolve it? I'm asking you this, Mr. Salve, because at one of the hearings, mediation had been offered by the Cyrus Mistry camp, but it seemed as if the Tatas were not warm to the idea.
The stage at which mediation was offered by the Cyrus Mistry camp was perceived, including personally by me, as a thinly disguised attempt to get a case adjourned which was going badly. So all that was not flying. I don't know how serious who is about doing what, so I don't want to comment. But as of now, I don't think anybody in the Tatas has applied their mind on what they want to do or not want to do.
As an outsider and just as an observer, Mr. Salve, do the Tatas even need to apply their mind to do anything, or because isn't it business as usual for them? They have not oppressed any minority shareholder. It's not incumbent on them to find any exit. But the same cannot be said for the Cyrus Mistry camp. We have all heard about those debt liabilities and how they want to monetize the shares. My point is, do the Tatas need to do anything at all?
Well, you're right. There will be, Tatas will now, once we see the judgment, the fine print, we will sit down and decide. And if we are in a position of strength, we may just sit tight for the present.